Sir James.
Well, can I very briefly go back on two things and two things only from this morning? The first one is an object lesson in not trusting your little instincts about the right answer in principle to a question that's asked by a court. There is some guidance on whether or not a lower court can amplify the reasons for their judgment at the stage of granting or not granting permission to appeal. And there is some authority on that and some reference to it in the White Book.
Yes, in a sense, it seems to be analogous with English and Emery Reinhold.
That's exactly the authority. My law is ahead of me.
Right.
There are two cases. Perhaps I'll just give you the references or show you the bit. Do you all have a White Book there? Perhaps you don't.
No, mine's been cleared away. I have volume 2 for another reason.
Can I give you a reference?
Just give the reference, yes.
So it's volume 1 of the White Book. It's in part 52, dealing with appeals, unsurprisingly, and the section there's a section dealing with a case called Greenwich Millennium and Essex Services, and that is essentially it's in the first 6 lines on page 1759 of volume 1 of the White Book.
Page
1759, and the White Book text says there, the Court of Appeal explained that where a judge of a lower court in refusing permission to appeal amplifies the reasons for their original decision, the appeal court in determining the appeal is entitled to take those additional reasons into account. And then it says these authorities are further considered below, and the below bit is on page 1808 of the White Book, and the key bit of on 1808 is the first full paragraph which analyses the case my Lord Justice Underhill has just referred to, which is English.
Yes.
And for your note, therefore, Greenwich, which is the first one I referred to, the relevant paragraph, as far as we're able to tell, is paragraph 7, and in English, the key paragraph appears to be paragraph 25. So apologies for the less than informed answer to the question when asked.
They couldn't really change the decision, could they?
Well, I'm sure there are. What led me to the note of caution. There must be limits of some description.
Must be a limit.
There might be a reinventing the wheel limit, but they are at least entitled to amplify. What that means, my lords will be capable of judging in the appropriate case.
You think after this case, Sir James?
But anyway, there is some authority, which you can make of it what you will. And also the other thing I wanted to just go back on, just to make clear that you have all of the relevant or the key evidence on it, is this point about funding and incentives and what money went to. Can I just invite you to go back to Mr. Armstrong's first statement? I know we went there very briefly before. Tab 26 of Bundle 3, page 1020 in Bundle 3 of the common document. Sorry, back 2 pages. 1018. 1018. Do you see a title at the head of Roman 3 and a further way down the page of funding?
Yes, so this is where we started last time.
Explanation of what money is going where and how is in that entire little run of paragraphs under that heading, which are Roman 3, Roman 4, Roman 5 and Roman 6. And again, I'll try again. If you just look at Roman 4, you will see that 20 million was made available on that date to Rwanda to allow preparations to be made in advance of the first vacations. Yes. Under the funding, will receive payments A and then B. So you'll see that there's specific and bespoke money going into what I described as the kind of structural things at the beginning. So that's Roman 4.
Sorry, I asked you whether 120 million had gone across. You said yes. Is that right or wrong?
It's gone across. I'm going to come to that if I may in a second. Just to take it in stages, this is the 20 million that goes to those structural things and is to be spent on the A and B matters that you see referred to in Roman 4. And you'll see in relation to the B bit, longer term welfare and so on, UK will provide financial support for each individual granted refugee status for up to 5 years. And then next sentence, the UK will provide support and integration funding for anyone refused for up to 3 years. That's why I referred earlier to the idea that there's more money coming.
these are the arrangements which I think you agreed with me don't incentivise anybody to do anything because they simply meet the costs.
Well,
There's no plus.
my lord, yes. But no doubt true in relation to this paragraph, so I start here.
Yes.
And then you'll go over the page, if you may, to 1019 at Roman 5. And that's the bit on the point my lord has put to me, which in the penultimate sentence of 5 says the total funding is that spent in the UK on the costs of processing each asylum claim as well as providing longer term support as a positive incentive to fulfil their terms. And
I mean, I suppose it's possible that the costs are actually less in Rwanda, so there is a hidden profit.
it's possible. I'm not going to get into that debate because that would be very
Yeah.
difficult for me to get into in circumstances where we haven't disclosed the NV that deals with individual costs. But then you'll see in Romans 6, which is the one that my Lord, the Lord Chief Justice drew attention to, you've got a separate thing. This is why I was concerned to go back to this. Because I think I suggested that 120 was to do with the structural thing. But it looks from 6 as though the 120, which goes across on the same date, is as part of the Economic Transformation Integration Fund, investing in Rwanda's economic development, including job skills and opportunities to benefit both migrant and host communities. So that's a general, I say aid provision, it isn't that necessarily, but it's a general provision of money to Rwanda. And then the final sentence, and it's separate from the 20 million, as it were, ring fence to the structures.
Yes, right.
And then you'll see what's said in the final sentence of 6.
Yeah.
Which is the incentivisation point my Lord, the Lord Chief drew attention to. So, my Lord, I hope it's helpful just to go back and expand that out a bit in those paragraphs. But
That's where the 140 million that was referred to before comes from. That's where the 140 million that was referred to before.
Exactly so, but it needs to be broken out into those two bits because one's going to the designated non-profit thing and the other one is more of an incentive. And you can see they'd be quite interested in that.
If there's an incentive, it will be the unspecified further amounts, which might be imperiled if the MOU were not complied with.
Exactly so, that's the principal one. And as you rightly point out, to the extent that there is a disparity between actual costs of provision and the comparative costs in the UK, there's a profit cost element there as well, potentially, but I'm not going to build on that. So I was on Rwandan capacity as the 6th of the points that I was dealing with. I want to take you to one other reference, bundle 4, if you would, tab 68, page 1348.
So, sorry, which tab did you say?
It's tab 68, and it's 1348 is the page number, and I want paragraph 19. Just because it provides a flavour. This is in the statement, as you remember you said, is that signed by a minister? And yes, it was, 1349. But if you look at paragraph 19, it just gives you a flavour of what the processes, what the structures look like and how they're being developed by Rwanda and so on. This is not a blank sheet. There are active changes being made to get the structures in place and make sure that they work. Just by way of flavour, anyway, paragraph 19. I don't know if Mr. Hussein on capacity said, well, we're not so much worried about capacity, but there's a broader or deeper truth, I think was the way he put it, that Rwanda doesn't understand the basic concepts. But those tie back to those built on the examples that were given of, for example, people being turned away at the airport. And I've made my submissions in relation to that, and I don't repeat them. There being in effect no risk of that happening here. And to the extent that there are broader concerns that are not to do with airport returns or refoulement, those are dealt with by the provisions of the MOU and the NVs and all the practical incentives I've gone through, so I don't repeat that. But in any event, and as importantly, there is the provision built into the NVs, built into the new structure and the new arrangements for lawyers to be involved and for the various stage processes which I'm going to come to be gone through. And that provides a significant degree of assurance, so too do the systems in place for monitoring, if there are issues in that regard. And if there were significant numbers of people in relation to whom the systems were, as it were, not working in an obviously significant way, such as of the kind of examples that were given by UNHCR, then that is bound to come to light, and is bound to trigger all sorts of concerns under the very arrangements set up by the MOU and the MVs. So that's the sixth aspect, which is to do with capacity and all of that. I wanted to turn briefly, if I may, to the specific aspects of the Rwandan processes and to the RSD process sequence as a starting point before coming to some of the specific areas of concern that have been raised. But it is at least worth bearing in mind, I respectfully submit, the basic nature of the new processes that are being set up under these arrangements. And there are perhaps it can be broken down into three stages. At the outset, there is a provision in writing to the individual concerned about the RSD process and the processes that are in place to ensure that they can properly participate. They are provided, and they have to be provided under the arrangements themselves, with a considerable amount of initial information, so they understand what is about to happen. And that is the subject of a specific provision in paragraph 3.1.2 of the Asylum process NV, Bundle 3, tab 14, page 695.
Which is 3.1.2.
3.1.2, that provides that all, page 695, tab 14 of Bundle 3, sorry, Mark. That provides that all relocated individuals will, quote, be informed of the procedure for making an asylum claim, for appealing a decision on their asylum claim, and what the relocated individual will be required to do throughout the procedure in a language that they understand. There will be, in practical terms, an orientation session that will take place the day after the individuals arrive, in which they're provided with detailed information about those processes, and interpreters will be available. See paragraph 7.1 of the Asylum process NV, and see Williams, Mr. Williams' statement, paragraph 32, 3.2, Bundle 3, tab 29, 1076. And there will be, as Mr. Williams points out in that paragraph, also written information, not merely about the RSD process, which will include contact information, but also information about making inquiries and complaints about their case. They are then given notice of their asylum interview and can be accompanied to the interview by a lawyer. See Bundle 4, tab 79, page 1440, final bullet. An interview transcript will subsequently be provided to the individual in a language that they understand, and they will have an opportunity to review it, if necessary, with their lawyer, and correct the transcript if they need it. See the Asylum process NV, paragraph 4.41. That's stage one, as it were, of the initial interview. Secondly, the RSDC process itself. They are invited, individuals are invited to provide written representations in support of their claim. 4.3.1 of the Asylum process NV, Williams, paragraph 34, page 1076. And they have the opportunity to make all representations directly to the RSDC. See Williams, paragraph 36, page 1077. The suggestion is made that this is too brief, as it were, but that, we respectfully submit, is not a tenable criticism. They have all the opportunities provided for specifically in the note verbal, and they will also have the officer's report and the interview transcript and the opportunity for oral and written representations.
And just remind me, but that is not representations, oral representations by a lawyer.
It isn't, I think that's right. I'm going to come specifically to legal representations. It's a topic that strands the three areas of process I'm describing. So I'm going to come to that in due course. I think that's right. There's then a suggestion that these decision makers on the RSDC are not up to it, and we don't accept that either. They bring complementary expertise from a wide range of diverse organisations that we submit, and if you want the organisations from which they're drawn, as it were, they are set out in bundle 4, tab 76, page 1393. Paragraph 4.2 of the NVs, the Asylum Process MV, requires that they be appropriately trained to take decisions on asylum claims.
Are you coming back to the case I want to ask you now, to the evidence about the extent of that training, which was raised by the UNHCR and sought to be answered?
Yes, my lord. I'm not sure. I think there's been I know, a debate on the papers about the extent to which UNHCR have been involved, and the extent to which.
Yes, I didn't really mean that, and I may be remembering it inaccurately. But UNHCR raised a question broadly about how they're going to be trained. They are basically asserting that they were untrained, didn't understand asylum law, and part of the answer was there was a 5-day training session, and also that some people had been sent on courses overseas. I'm remembering it slightly impressionistically, but you were aware of the evidence. And then UNHCR came back and pointed out that a lot of people didn't actually attend the training or didn't attend all of it, and the ones who went abroad, it didn't seem possible to identify what the courses were that they'd been on.
Well, yes,
I just wanted to know whether you're going to address that.
I don't know whether we've got final resolution on precisely what the details of all of that are and where that lands. I'm aware that some concerns have been raised. Will you just give me a moment? I'm going to whisper that. There's an invitation out to put some bullets together about some of that if necessary. So I'm very happy.
Speaking for myself, I think I would like to have in one place what the evidence about that is, because you obviously see the point. It's one thing to say there will be training. It's another thing to have some idea of what the training will consist of and whether it will actually be taken seriously.
My lord, yes. But I mean, if the purpose of that is that none of this is going to be taken seriously, there is there's obviously pushback.
It's certainly not an allegation of bad faith, but it's an allegation of the gulf which in the real world often happens between aspiration and reality.
Of course, but the fact of the matter is that a concern about training has been raised. People have gone out of their way in the arrangements that are set up to include a requirement that decision makers are appropriately trained. And again, all of these things will necessarily take time to bed down, time to work. But the fact of the matter is that the arrangements are in place for that to happen. There is no question but that the members of the RSDC are capable of getting to a place in which they can make perfectly sensible decisions.
You see, Sir James, that as far as speaking only for myself, when you make a submission like the arrangements are in place, to me that needs to be verified by reference to evidence and needs to take into account the evidence of the UNHCR that the culture, if you like, of the asylum process is not likely to be receptive to these aspirational requirements of the MOU and the NVs. Now, it's easy to say arrangements are in place, but if that is the submission, and we're supposed to, and the Divisional Court was supposed to accept that, then we need to know what they are.
Well, my lord, you don't have chapter and verse on every part of the arrangement processes. And and frankly, one will be here forever if that were the position. This is a new set of arrangements, which all the indications are being taken entirely seriously by the government which signed up to them, namely the government of Rwanda. And the submission that I would make is that in relation to a setup like this, with all of the incentives I've identified and all of the level of detail, in part reacting to some of the concerns that were raised by bodies such as UNHCR, but not exclusively them, the proper approach for a court to take is the one that the Divisional Court took, which is to say, here is a process being set up. It is a brave new world. There is a bunch of detail on it. No doubt it will take some time to get all its elements up and running in a perfect form, but no cases have actually gone through the system to test it as yet. And the idea that the Rwandan government will, as it were, be culturally intolerant or culturally reluctant to take the necessary steps to comply with those arrangements, there is no support for whatever.
Yeah, I don't think that's the point. I think the point that's being made against you is whatever the Rwandan government thinks about these obligations, the arrangements that are actually in place when the decisions in relation to these 10 asylum seekers were taken at a time when there was a real risk because the existing arrangements were not satisfactory. And I know you say it's a complete answer to say that the government has given assurances and there's no reason to suppose they won't want to give them effect. But I'm just wondering if what your answer is to the suggestion that arrangements are actually on the evidence not in place, and how are they, and to the question, how are they going to be in place, taking the decision as at May 2022, when, as you rightly say, nobody's been to Rwanda, all you've got is the MOU. That's my question. I mean, I think it sort of runs through the whole of your submission, so it's not, you don't have to address it specifically now.
I do understand. I mean, the process that has been gone through is to, as I say, is to try and react to the concerns that have been raised, to produce specific provisions if there are areas of concern, to ensure that everyone who's going to be handling the system fully understands what is required of them. What we don't have, as it were, is a mass of evidence going across the board about each of the individual elements and where they've got to. But in my respectful submission, that isn't necessary. If you assume, as you must, or as we invite you to, and as the Divisional Court found, that there are plenty of good reasons for the Rwandan government to comply with these arrangements and to put in place whatever practical steps are necessary to meet them, then that sort of evidence isn't necessary. I mean, we haven't got evidence before you that says they went on this training day then and that training day on the other thing. The requirement, however, in the MV and the commitment seriously undertaken is that they will be appropriately trained. If people need to discuss that further and make sure that that has been in place and is in place, then so be it. That isn't a reason for concluding that the system is incapable of operating in a way that will not operate in practice, in a way that conforms to ensure that there is no real risk. But I can't, as it were, point you to a statement that says, here are all the NV commitments, here's where we are now in relation to all of them. Well, the final one in relation to the RSDC is in relation to written reasons. And again, in relation to that, if you still have the Asylum NV open, you will see on page 697 of Bundle 3 behind tab 14, paragraphs 48 and 49 of the note verbal. I've touched on this in earlier submissions, But again, the same point can be made. Well, how do we know that they're going to do it? We've seen an example of a case in which it was unreasoned. But again, it's the same answer of principle. A specific set of provisions have been agreed to by them, and there is no basis for assuming that that will not provide sufficient. The third and final stage of the process is...
Sorry, just before we
Yes.
get to that, another criticism was that the evidence was that the practice of the RSDC was to hear decisions in batches. I think 40 being heard in one session. It may well be your answer is that that won't happen under the new regime.
Well, I don't know whether it will or it won't.
Well,
the fact of the matter...
Well, that isn't... but that's really essentially my point. I'm not aware of any answer to that particular criticism, though I think it is a criticism that UNHCR did make contemporaneously, not just forensically.
Yes, well, you have to bear in mind that and that's almost a paradigm example. If it's said, I don't know whether it's accurate or not, they tend to determine things in batches. What is envisaged under this process is a process that conforms to the requirements of the note verbal. And at least in the initial stages, there will be a relatively few number of people, because of the TAP provisions that I took you to earlier, going
Yes.
through the process.
Right.
So if they were confronted with 800 people in a sudden crisis, then no doubt one can see an incentive for doing things in batches. But if you're dealing with, as it were, a trickle initially through the pipe, controlled by Rwanda, which knows that it's got to produce fully reasoned decisions, including both fact and law, and it's got the High Court sitting above it with a BDI, as it were, then the history is only of minimal significance. The fact of the matter is that they know they've got to produce a system, and they've got all the incentives to do that. It's almost it's not a bad example of the dangers of just saying, well, there's a history, ergo inference, they're culturally unable or would culturally be unlikely to conform to the specific requirements that they have signed up to in these documents, knowing full well that if it doesn't work properly, it will be shut off, and all the incentives we looked at a minute ago will not continue to flow. There are powerful incentives to try and do this right. There are lots of people on the ground there to try and help. Home Office is embedded out there. If they think they need assistance or there are concerns, this isn't just something that's written down on paper. All the indications are that whilst this was being negotiated and subsequently, the UK government has been doing lots to try and ensure and check that the processes are in place and to assist in delivery where appropriate. Yes, and I'm reminded, helpfully by Lord Panic, that paragraph 4.6 says what it does. They don't just have to give reasons on fact and law, but they've got to be taken on the merits of the individual application. Yeah. So the final stage is rights of review, rights of appeal, and access to legal representation on appeal. As I said earlier, and as guaranteed by 4.9.3 of the NV, if you still have that open on 697, they'll be notified of the right to appeal to a minema against the refusal by the RSDC, so there's an internal appeal, as it were, and then secondly to the High Court should minema dismiss the appeal. That provision of the note verbal 4.9.3 is then dealt with by Mr. Williams at paragraphs 38 and 40. 38 and 40 of his statement on the 3 tab 291077. And as I said, they have an opportunity, see paragraph 5.1 and following of the note verbal 697, to make oral and written representations to minema. And a legal representative will also have the opportunity to make submissions, as you see from 5. And 5.4, there seemed to be some suggestion yesterday from UNHCR that there was a doubt about the jurisdiction of the High Court. See for that purpose paragraph 5.4 of the note verbal. Full re-examination of the relocated individual's claim of fact and law in accordance with the rules of procedure. The core point here appears to be an attack on the independence of the Rwandan judiciary. And that appears to be based on a judgment of the Divisional Court, which I want to go back to. The Tezi Rayu case, in bundle 20 of the call authorities, tab 42, starting at page 1295.
Could I have the bundle number again? I'm sorry.
20, my lord, I'm so sorry.
No, it's my fault.
Bundle 20, tab 42.
Something else.
Tab 42, starting at page 1295. So it may be quite important to bear in mind in relation to this case. This was an application for extradition inviting the return of individuals who were Hutus to be tried on charges of murder in connection with the genocide in 1994. And the victims, by and large, of that genocide were the Tutsis, who are now in charge and were at the time of this judgment in charge. So you had, as it were, the tribal opponents, or members of the tribal opponents, being returned, or prospectively being returned, to Rwanda to face these sort of charges in relation to a subject matter, the genocide, which it might be thought was about as fraught as one could possibly imagine. And just to, we can see that from judgment paragraph 5 on page 1297, a summary of those where Hutus are called on to disassociate themselves from the Tutsis, who were said to be the enemy. That's the kind of flavour of it. But it's tribal opponents, as it were, being transferred back or expedited back to face those sorts of charges in relation to that sort of awful and fraught historic context. The appeal to the Divisional Court from the decision of Senior District Judge Arbuthnot raised the grounds that you can see in paragraph 13 on page 3781. And you'll see the extreme position taken by both parties in paragraph 40. The RPs, that's the people who are about to be extradited. I can't remember what RP stands for.
Requested
person, sorry. Submit that the Senior District Judge must be understood to have found there was a risk of interference by the government of Rwanda with the judges who would try them. So they wanted that finding, very specifically, that there was a risk that they would interfere. And they cross-appealed on that basis. By contrast, the government of Rwanda was inviting an entirely clean bill of health finding, and that there would be no unfairness, and so the extraditions could proceed. You will see that the reason that the government of Rwanda was taking that position, despite the findings of the Divisional Court in Brown, which I think was the Lord Justice Law's one earlier on that you see referred to at paragraph 38, 38 of the judgment in 1305, was because there had been significant changes since that judgment in the set-up and operation of the judicial system in Rwanda. you see that recorded in paragraph 46. And so the issue against those binary positions taken, extreme positions taken by the parties, was quite what to do about all of that in the light of those developments. Had they gone far enough or not, and could everyone in England be satisfied that there wouldn't be a prospect of flagrant denial of justice, and or should the court decide that there was a risk of interference by the government of Rwanda with the judges? And the judgment of the senior district judge is summarised from paragraph 55 onwards. And there was a specific concern about whether or not the defence representation was likely to be, as it were, virile enough and strong enough to deal with any concerns about fairness. That's ultimately what the thing came down to. See paragraph 59, where they draw the threads together on the focus of the senior district judge. Then they consider the well-known cases to do with the real risk of flagrant denial of justice, Buller and so on, Ian Lebanon, and that proceeds. But then ultimately, after a lot of detailed analysis, you will see that the key passages in this judgment, which relate to the independence of the judiciary, are on page 1363, at paragraph 234, down to 240. So 1363, 234 to 240. I just invite you to read those paragraphs. 234 to 240.
Could you remind me what ICTR stands for? I think I know what it is, but I've forgotten the precise.
The
Is it
International Court on...
Anyway,
I'll find it.
Thank you.
International Court on Rwanda. Criminal Tribunal for Rwanda.
Thank you.
Defined in paragraph 27, right?
Yes.
Of the 550.
Yes.
The short point is, as you see from those paragraphs, the finding is a relatively nuanced one. It is that there were concerns about the independence of the judiciary, perhaps understandably given the extremely fraught context and who it was who was being extradited or might have been extradited to face what charges and in relation to what. But there were some concerns about independence. But ultimately, what the court decided was, although acknowledging that there were some concerns on that front, particularly given the fact that considerable strides recorded earlier in the judgment had been made in relation to the Rwandan justice system, criminal justice system as a whole, some concerns remained about independence. And so the critical question was whether or not that, as I described it, the defence lawyers were going to be virile enough to properly present the case and ensure that the thing went properly. This is not, as it were, a full-blown assertion that for all purposes and in all contexts, the government sorry, the Rwandan judiciary cannot be trusted and cannot be regarded as being impartial, independent. This is a much more nuanced set of findings, and I would add a much more nuanced set of findings, even in a context in which the extradition was of the kind that I've indicated.
I thought there were. I'm sorry, I haven't looked at this in the last day or so, but I thought there were in fact findings that the Mr. Whitveen's evidence as to the impartiality of the judiciary, the willingness of judges to find against the government was doubtful.
Yes, there was some doubt about that, which explains why the findings were as nuanced as they were.
Well, no, I thought that that's paragraph 390 and then the conclusions on fair trial at 365. I mean, I haven't looked at them. 370, as we've stated above, the evidence suggests Rwanda has, if anything, become more of an illiberal and authoritarian state than it was. Blah. I mean, it goes on and on. I mean, but there's a bit more to it than the nuanced findings at 234 to 240.
Yes, but there is on some of the worries about Osman warnings and all of that. But the passage in which the court deals with independence of the judiciary is the passage I've directed your attention to.
Well, you say that, and you're probably right. You've read this more thoroughly than I have, but 373 and 374 start as to the independence of the Rwandan judiciary. Yeah. It goes on to make some fairly firm findings. I don't quite know how that relates to the passage that you've shown us earlier. Obviously, I don't understand the structure of the judgment more fully, but on their face, 373 is quite worrying about the independence of the judiciary.
But you need to read 373 with 374, which are entirely consistent with the nuanced nature of the findings.
Sir James,
earlier.
I mean, I think you have to be careful with this judgment. I've highlighted from my previous reading of it the last sentence of 3C74, which is that their view is that the evidence points to some risk, depending on the evidence before them and the safeguards in play, that judges might yield to pressure from Rwandan authorities. That looks like a conclusion.
Well, my lord, it is a conclusion, but it's a conclusion which is consistent with the passage I took you to earlier, which summarises their findings.
But do you submit that's evidence of an independent judiciary?
My submission is that you can't reason from this case to conclude that in the circumstances that we are concerned with, and what you're effectively being invited to do here is to, as it were, ignore the safeguard that is provided by the right of appeal.
Well, it says depending on the safeguard.
Depending on?
That sentence actually says depending on the safeguard.
Well, and depending on the evidence before them, I think.
Yes, that's the problem.
I mean, it's extremely difficult to draw system-wide conclusions from a single case of this nature, as it seems to me, anyway. And without having read every one of the 374 paragraphs that preceded, some risk, depending on the evidence before them, and safeguards in play. So I'm not sure what safeguards the court is referring to there. Maybe it's obvious when I have time to read it more thoroughly.
But it depends on the context as well, which is the critical.
Yes.
And here you've got a context in which they're being asked to be, as it were, sanctioned as a thing that doesn't create the real risk of a flagrant denial of justice.
Yes.
The return of individuals who, as I said earlier, the tribal opponents to face charges of murder in relation to the genocide. Whereas here, we are dealing with a situation where the thing is, if anything, the reverse. I mean, you've got a commitment to an appeal process in the arrangements. You've got no animus. Why would the government of Rwanda have an animus against people returned or removed from the United Kingdom? For them specifically to process, in what is envisaged to be a fair and appropriate way, their asylum claims, where the government of Rwanda is going to be provided with money for 5 years if the answer to that question is yes. Compare and contrast is really the short point in relation to this. Now, I fully appreciate that in terms of principle, judicial independence is judicial independence is judicial independence. And that's different from impartiality, the convention conception of it. But the fact of the matter is that it all does depend, I respectfully submit, on the context.
I think at least part of Mr. Hussein's submissions was that what they would effectively be asked to do was to overturn the decision of a government department. And as you say, that's a very different sort of context from the genocide case. But some of the findings made in the genocide case suggest, they have to be party members, they are appointed for definite terms and so forth, that there would be a concern that if they allowed an appeal against a government department, that would be a black mark.
Well, no,
I'm simply putting what Mr. Hussein,
yes.
one part of what Mr.
And my respectful submission is to go back to the context, to go back to the arrangements, to go back to the specific guarantees and provisions, to go back to the composition of the RSDC, and fundamentally to go back to the idea that there is no animus here. That this whole process is being set up to enable determinations to happen. The fact that it's not a decision in relation to whether or not a political or tribal opponent killed someone in 1994 in the worst genocide in history. It's just fundamentally different. They're there with all the incentives provided in order to provide determinations. It would be yes or no. And on one view of this, they're a great deal better off if they say yes.
You may be going to come to this, but I haven't seen, it may be in the bundle somewhere, any observations by international bodies or things like United States State Department reports on Rwanda expressing views about the independence of the Rwandan judiciary in the last...
I don't think there's anything in there apart from to note that the UNHCR do not raise and did not raise judicial independence as a concern.
I thought, Sir James, I'd seen in reading the papers the American Bar Association has something called the Rule of Law Index, which includes, I thought I'd seen that report in these papers. Is that, am I right?
Will you make, I'm sure, my lord, I'm sure you're right, your recollection will be better than mine. It doesn't immediately spring into mind.
I can't remember what it said, so
No.
it's not for you.
Sure.
It was in tabular. No, it was rather. I'm not sure I'll be able to find it quickly. It was. You have to read it quite carefully to see to what extent it's actually relevant. And I certainly wouldn't mind being taken to it at some point. Because
We'll see at least if we can track the document.
There are quite a lot of these indices around the place, and they're not only concerned with what the judiciary is up to in any particular country.
No, I seem to remember this had scores on a number of factors.
That's right.
The one that I had in mind.
Yeah.
But we don't have, for example, up-to-date State Department reports on Rwanda, which I would lay a pound to a penny would say something about this. But there we are, we don't have them.
You don't. Well, as I say, we noted below and we note again, UNHCR are not running this argument. They're not taking this one. They're taking every other point. They're not taking this one. Maybe some indication that they recognise there's a pretty significant difference between the sort of context on which this claim is built, this aspect of the claim is built, namely the extradition argument.
Well, part of the difficulty for everyone, I think, is that, as people point out on each side, this jurisdiction for the Rwandan judiciary is totally new. So UNHCR wouldn't be in a position to say, we have observed X, Y, and Z cases and things have gone wrong. Likewise, you wouldn't be in a position to say, there have been lots of other cases and they've gone right. So we're back in your predictive problem.
We're back in the predictive problem, and they're back on the question as to whether or not you can reason from this judgment in the Divisional Court, in this specific context, that you can't place any reliance upon the provision of the full-blown appeal right, properly represented, properly lawyers are able to fully participate in all the rest of it, that are guaranteed in the NV.
Strasbourg, when looking at questions of this sort, tends to like to be shown authoritative reports from respective bodies. I'm not really aware of any Strasbourg case where they've founded a decision on the findings of a single court in a single jurisdiction. But I mean, it is quite surprising, at least to me, that we don't have, and the court below didn't have, reports from the sort of organisations whose reports we see all the time dealing with deficiencies in countries, including deficiencies regarding their legal systems.
Well, I'm not aware of any. You have what you have. We'll see if we can find the specific document referred to. My Lord is also very well aware that the Strasbourg Court, although it has developed the distinction between impartiality and independence, tends to view the distinction between those two concepts as slightly more hazy and fluid than perhaps an English law might do, and is also very keen to emphasise the idea that everything is critically dependent upon the context when you're considering those sorts of issues.
Well, I don't want to interrupt Mr. James unnecessarily, but just to give you two references, if it would help you. It's the Human Rights Watch letter from, I think, July 22, around it anyway.
Yes, you showed us that on.
Did I show you? I was just giving you the reference.
Monday,
for
yes.
It. So it's volume 4, Common Bundles, tab 64, page 1322.
Yes.
The reason that's important is because our court laid a lot of emphasis on the views of Human Rights Watch. Almost their entire evidential base was human rights.
You mean in the extradition
case?
Yes.
And the other reference is to the Foreign Office.
Yes.
The Foreign Office reviewer, and that's also Common Bundles, hard 4, tab 53, page 1225.
Yes, I think you showed us that on.
I don't think I showed it to you.
Well, you gave the reference. Yes, that's right. Thank you, Sir James.
Well, that's all I want to say on independence of the judiciary. Until I want to pick up some general areas, if I may, that strand the 3 areas of process, the 3 discrete stages of the process. And the first is legal assistance. There was quite a debate below on whether or not access to legal assistance was sufficient, and very little, if any, real emphasis on that certainly in the oral submissions before you. So I can take it relatively quickly. You will have seen that there is access to legal assistance guaranteed in the MOU and the NVs. The MOU, the reference is 9.1.2, Bundle 3, tab 13, page 685. And the NVs deal with it in paragraph 7 and 8, as you've seen, the asylum process NV at tab 40, the same Bundle 3, page 698. Paragraph 7 of the NV talks about legal representatives being able to provide legal assistance at every stage of the claim. And if you wanted the detail on legal assistance, which, as I say, much more to the fore in the complaints below than here, perhaps the best reference is to our skeleton below at paragraph 8.26. Gives you lots of references to the various documents. Bundle 2, tab 11, page 554.
So sorry, will you give me that reference again?
Bundle 2, tab 11, page 554, paragraph 8.26, which you know that has a number of sub-paragraphs.
And I'm sorry, when you before the reference before, I didn't write down either. Where were you reading from?
Those were the MOUs and the note.
The MOUs themselves.
Yeah, so MOU 9.1.2. I won't give you the bundle reference again. 9.1.2. Asylum note, process note verbal 7 and 8. Dealt with in that. And then for the detail of how it works, see the Scully below at 8.26. The Master of the Rolls question about the number of lawyers in Rwanda, and the question he frequently asked when visiting. I think the answer for that is probably on in page 1392 of Bundle 4, tab 76, 1392 of Bundle 4, more than 1,100 senior registered lawyers in Rwanda, and more than 300 intern advocates, whatever they may be, maybe pupils, and then describing what you have to have and what they're trained with. And then there was some evidence below about the number of lawyers specifically trained on refugee protection. I think there was an email which set out that the number particularly trained on that was 34. That is bundle 31. That's one of the supplemental ones. Bundle 31, tab 3, page 23.
Is page 23 is of which bundle?
It's a bundle 31 bundle.
But is that?
Which is, I'll give you a description if you give me 1 second.
It's called the additional supplemental.
Further supplemental.
In the case of AS, right?
Yes, exactly. Just to flick through the stages, that the interview stage with DGIE, lawyers can attend the interview, but that isn't provided free of charge. See bundle 4, tab 791440, reference I've given you before. Same thing at the RSDC stage. And at NAMA and then the High Court, there's legal representation provided free of charge, pursuant to an agreement with the Rwandan Bar Association. And I've given you the reference to the 34 advocates trained in Asylum. So there was a bit of a debate around, below at least, around the reality of pro bono representation, whether that was available. There was a great thing about that. But can I just give you references into the witness evidence? Is probably the most convenient way of dealing with that. C, for that purpose, and the reality of pro bono, effectively, where the state isn't funding it, those earlier stages. Armstrong, paragraphs 55 to 60. Bundle 3, tab 26, 1036, and Williams, 34, paragraph 34 and 40 to 41, and those are in the same bundle, tab 29, page 1076 will get you there. So we respectfully submit that there's rightly been much less focus on legal assistance. So although there are some limitations on funding and so on, there is pro bono. People are allowed to participate. There's access to legal services, an integral part of this process at each of the stages. Possibility of access is provided free in relation to the appeal to the High Court on fact and law. But there, again, we had a big spat below about interpretation services and whether or not they would be adequate and how all that would work. I'm not going to deal with that really at all. But if you want the detail on that, C, for the guarantee, again, people thinking hard about the practicalities of this and how it's actually going to work in practice. The guarantees of making sure that interpretation services are around and available and people can understand what's going on. MOU 9.1.2 and the note verbal 9.1 to 9.3. Guarantee of a provision of interpreter free of charge to relocated individuals where that might be required. And again, if you want the detail on that, Skelly below, bundle 2, tab 11, skeleton below, R skeleton below, paragraph 8.27. Just to sweep one final point away before coming to the DGIE specifically, because of the focus put on that by UNHCR. Confidentiality, again, was a considerable spat below and has rather dropped away. And our short submission on that is that it was right that it's dropped away. It was a non-concern that had been raised by UNHCR in particular. Judgment paragraph 56, that's dealt with, and we submit that was correct.
I'm sorry to interrupt Sir James again. I was wondering whether to do it about a minute ago. Neither lawyers nor confidentiality.
Well, look, Mr. Hussein, you have a chance to respond.
I'm so sorry.
And if Sir James has inadvertently given us a truncated version which doesn't state the whole position, I think it would be better to keep them until you respond.
Page 11, R skeleton.
Yes, yes. Well, you did. Yes.
DGIE I was going to focus on specifically, if I may. Yeah. And I do so principally because that's the first of the bases, the core bases for UNHCR's position before this court, taken in their reference document, for saying that you can't approach this on the basis of what they describe as a clean slate approach. And you'll appreciate the significance that we and the Divisional Court have attached to the detail, specificity and newness of these arrangements, but they mount a series of objections to that on the basis of the DGIE's role. And as I said earlier, the Divisional Court did not say that the history was irrelevant or that the concerns that the UNHCR might have raised were irrelevant. They simply focused principally on the arrangements themselves and whether or not they could have confidence that they would be implemented, and concluded that they could, in which case the historic stuff diminishes or at least recedes in terms of its relevance, if that conclusion can properly be reached. And the basic thrust of the allegation that is made in the UNHCR submissions at paragraph 6 in particular of the reference note that you were handed up to you by Mr. McCulloch, is that the DGIE exerts and will continue to exert undue influence on the process and or will be playing some form of an unacknowledged role in the decision-making process, and, which is a necessary step, will continue to do so under the new arrangement. So the first aspect of that is the DGIE's role as gatekeeper, as they put it. So they sought to emphasise that DGIE had in the past been involved in what they described as off-the-book decision-making, where DGIE plays an unofficial gatekeeper role in which the asylum claims are never referred to the RSDC for decision. That's what they mean by gatekeeper role, so an intervention to stop the process from happening. And the answers to that are, first of all, that the whole purpose of the arrangements, the MEDP arrangements, is to transfer individuals to Rwanda for the very purpose of processing their asylum claims. That's the very basis on which they're being transferred. And moreover, as you saw from the MOU paragraph 3.2, Rwanda specifically consents to the transfer of each individual before the transfer for that purpose. Secondly, there is, as I indicated, a clear process set out in the arrangements themselves, with all the very real, practical, reputational and financial incentives to comply with it. And that process includes each of the 3 stages of process that I identified. Initial interview by DGIE, followed by RSDC, followed if appropriate and necessary by appeal to the High Court. And so if individuals are transferred, having been accepted by the government of Rwanda for this very purpose, and don't see the light of day, as it were, because DGIE has intervened in some way, then it's inconceivable that that will not come to light. And it's inconceivable also that the most serious questions will not immediately be asked. And we know from the detail of the monitoring arrangements that that is not going to go uncovered, because everyone will have a record of and will know who has been transferred. There is detailed access guaranteed by those monitoring provisions to ensure that all elements of the process can be opened up to the monitoring bodies involved. And so those practical concerns, even if there was a risk of DGIE acting as some form of gatekeeper so as to prevent the process or a decision being taken by the other bodies later on in the process, it's just simply never going to happen on any realistic view. So there are, as I say, processes in place. Just to give you a couple of references, I referred you earlier to the monitoring committee terms of reference. Do you remember in Bundle 4, tab 82, page 1597. But you will see from that there are all sorts of guarantees of and specific consideration being given to the practicalities of monitoring. Page 1, scope, it says, the MC will monitor all areas of the relocation process covered by the MOU and the MV, both in the UK and Rwanda. Page 2, the conditions on which it will report include the processing of asylum claims. Page 2 again, will have unfettered access for the purposes of completing assessments and reports. So we do respectfully submit that that is an important part of the process. And there are also, as Mr. Williams and Mr. Krellin's statements make clear, there's also Home Office embedded overseeing arrangements within Rwanda, providing yet another layer of protection. There is, I want to give you one reference to a Home Office internal report, simply to make the point that, as that points out, the process is going to involve the recording of decisions being stored digitally on a bespoke asylum IT system, and that the individuals concerned will be easily identifiable in the process with a unique reference number and what's described as a strong audit trail to capture dates and the details of key decisions. So that also another important practical element enabling people to be tracked through the system.
Have you got a reference for that?
Bundle 4, sorry, tab 74, page 1366.
Thank you.
So DGIE as gatekeeper is a non-point, I respectfully submit. The second aspect of DGIE, which is focused on, is the role of the DGIE in the processes that follow, and that's a second key basis for attacking the clean slate approach. The assurances themselves, as you see, provide for an objective and impartial process. That isn't just some form of laudable aim, it's a requirement. And the attendant procedural safeguards have been considered with immense care and in detail in the various documents that you've seen, culminating in access to a court with full jurisdiction. So there are important concerns about important safeguards in place. If there are concerns about the role of the DGIE or how they've conducted themselves or what part they've played in things, then the matter can be raised. In fact, the position is that the DGIE is responsible for registering the asylum claim and conducting the interview, preparing the file for the RSDC. They don't make recommendations to the RSDC, as the evidence made quite clear. And moreover, individual legal representatives will have access to that file. See the earlier reference to the digital system and all of that. But the individual legal representatives will have access to the file.
Have I recalled correctly that there will be at least one DGIE representative on the RSDC?
No, you've recalled partially correctly. That's the position. The position.
Tell me.
The position, in fact, if you want it, is in Bundle 4, tab 76, page 1393, which sets out the composition of the RSDC. And I think the position is that the National Intelligence and Security...
Page?
I'm so sorry.
Which particular page did you say?
I think it's 1393, says my
Sorry,
note.
yes, I just...
Bottom right-hand corner
Yeah.
of the table.
You see the reference to NISS, the National Intelligence and Security Service.
Yes.
I think the position is, from memory, I haven't got all the references to hand, we had a bit of a go at this below, but I think the position is that the DGIE is a part of, but only a part of, the National Intelligence and Security Service. But it isn't, I think, the position that there will, as it were, automatically be a DGIE member sitting on the RSDC. And of course, there are 11 groups of people from whom they can be drawn, that's the diverse range point, and the quorum from memory is 7. In any event, I'm not entirely sure why, even if some member of the DGIE did sit on the committee, that would be potentially particularly problematic. I mean, there's no basis for assuming that they are beyond the pale simply by virtue of being a member of the DGIE. And of course, if there was a concern that they were sitting on a decision which they've been involved in the interview of, then that would become apparent and objections could be taken and that could be ruled on if necessary. So their role in the processes that follow is a non-point also, we respectfully submit. So key bases on which it is said, well, you can't rely, this is the core thesis, you can't rely on the existing structures because the existing structures are bust, it is said, and they're going to continue to be bust. But the answer to that is, or the answers to that, are the ones that I provided in relation to DGIE, which really lies at the heart of this UNHCR thesis now produced in the references note that was handed up to you. And we do submit that they are non-concerns in relation to DGIE. And so a very significant part of the objection to adopting the clean slate approach, if that's truly an accurate way of describing what's happened, which it isn't because the government was well aware of history and took into account the concerns in designing the safeguards and the assurances. But a key part of the objection just simply falls away on analysis. Then there are objections that are raised in the reference note that UNHCR handed up to you under the title Right to be Heard, 6b. And the suggestion again appears to be the system is bust and the system is going to continue to be bust. And we simply do not accept any of those points designed to support the idea, which is belayed by the title of that section in 6b of their references note. What they truly appear to be saying is there isn't any right to be heard, and there wasn't, and that's going to continue to be the position. But you've seen the processes specifically guaranteed by these arrangements. It said, therefore, that the DGIE conduct an inadequate interview. But in relation to that, the government of Rwanda's response provided, following a request made under the MOU's provisions which we've seen, the MOU's response to that is at bundle 4 tab 67, page 1335 under A, where the allegation is recorded, 20 to 30 minutes interview, no opportunity to state why they left their country of origin, no opportunity to address adverse points. And the government of Rwanda is trenchant. They say, not true. The interview takes as much time as necessary for the applicant to explain clearly his or her case. Guiding questions are set in a way that provides the opportunity to provide all information. Applicants can be invited for more interviews if necessary. And again, if the lawyer can be present and the pro bono is a reality, there can be objection. But there is nothing in that point at all. Then they said there's no right to lawyers' participation at the administrative
Well,
stage.
hang on, sorry, this is at the initial interview stage?
Yes.
I thought lawyers weren't allowed to be present then.
I think they can be, I must remember that, they might be present but not paid. Yeah, it's 1440. I gave you that reference earlier.
I'm sorry, I obviously didn't take it.
1440 is a final bullet. They can be present but it's not paid for. I think the basic division, if I've understood it correctly, is that you can have lawyers at all parts of the process. They just get paid for at the High Court.
Yes, I see.
Does that make sense?
Just read the next paragraph, please, on the page.
1335, that
Yes.
page. Yep.
Yeah, well, of course I'm very happy to do that.
Sorry, I'm in the wrong place. I'm at 1440. Where am I supposed to be?
I think you're being invited back to 1335.
It's entitled Lawyers Cannot Attend.
Okay. Then we've got inconsistent references.
Well, that's interesting. That wasn't actually what I was asking about, but
This is the government of Rwanda's response. And it says lawyers cannot attend.
That's the RSDC. I was actually asking about the initial asylum.
Yes.
I mean,
That's the previous paragraph.
Yeah, the reference I gave you earlier was 1440, which is from the Chief Technical Advisor for the Ministry of Justice, Attorney General of Rwanda. That's behind tab 79 in bundle 4. I think that's the reference I gave you earlier. Final bullet, you see under legal assistance.
one moment, sorry for
So it's a conflict because it says they can attend both the interview and the RSDC, whereas the government of
Yes,
Rwanda's
and there may be
response
some
says
discrepancy
they
there.
can't.
But the point I was on was not so much, I mean, I see that, and worth chasing down, of course, but the point I was on was that there was the interview process as a whole by the DGIE was inadequate. It was short and cursory, appeared to be the suggestion. And that's the one that the government of Rwanda took serious objection to in the manner that I indicated in 1335. We've chased down the bit about lawyers' participation. Not entirely clear, but there's plenty of legal involvement, if I can summarise it. And there's plenty of opportunity for legal assistance. And it looks like lawyers can in fact attend the interview query about the RSDC and that part of the process, but they can be involved in assisting them to prepare for that. So legal assistance I've covered. No guarantee.
Sorry, I just don't want to slow you down. Under our system, is it not normal to have lawyers at the asylum interview, or is it?
I don't think it is.
For the initial screening interview.
Yeah, I don't think so.
Might be said to be different in Rwanda because
Maybe
a different system.
And then the decision is made on paper, and lawyers become involved at the tribunal stage if there is an appeal against an adverse decision.
But the concern, there was going to be a concern here.
I've got a shaking head.
Yeah,
So where did the lawyers become? I mean, actually attending. So they're involved, but a lawyer doesn't attend to make representations to the Home Office caseworker. Is what I mean.
the usual system. If a lawyer gets involved, they will write.
They will write, yes.
But there won't be a hearing.
That's right.
Well, there may be intricacies here, there may be intricacies in Rwanda that we've seen, there may be some inconsistencies.
Yes, but I was just, as a reality check,
to see quite how it
points to be made all ways, but our system does not provide for lawyers to be entitled to attend the screening interview, and there isn't a hearing before the first decision. Of course, there is then a fully judicialised process thereafter.
Well, the core point here is that if one is going to say, well, you're stuck with a busted system, and the busted system is going to carry on, it's got to actually grapple with the ingredients of the thing that are put in place in the note verbal and in the arrangements that have been made. And so far as legal assistance is concerned, you can have the sort of debate that we had below. I can understand that, which says, well, there you go. You say there's going to be, it's a bit like my Lord the Master of the Rolls point on legal assistance. You say, well, you know, it says legal assistance, but how do we know there's going to be legal assistance? And if you can't pay for them, and it's got to be pro bono. We had that exploration below, but the fact of the matter is that there is provision for lawyers to be involved at all of these stages, and the intricacies or the precise nuances of exactly how may matter less than the broad point, which is that there is specific and detailed provision for legal assistance.
I have to, I just put this to you so you can deal with it. I mean, to me, I come back to the test, which is real risk. So saying the system is busted is not particularly helpful, and saying the system is perfect because it says that in the MOU is not particularly helpful. The question I think the Divisional Court had to answer was, is there a real risk? Now let's assume for a moment that we had to answer that question. Obviously that very much depends on the view we take. How do we approach that where one side is saying it's all terrible at the moment, and you're saying it's all going to be wonderful under the MOU.
Well, I think my answer to that is that you have to be guided in the first instance by the approach of the Divisional Court and applying a proper appellate BDI to findings of fact and challenges to findings of fact that they might have made. And if and to the extent that you delve a bit deeper into the evidence and they haven't dealt with a particular or specific point, then you have to do what you can on the evidence. That's why I'm going through, or trying to go through, this slightly more detailed process.
There is a disconnect, isn't there? Because the evidence on what you draw our attention to is the MOU and the note verbal and the evidence which says we've been assured it's going to be fine. And what they draw attention to is evidence that it's not fine at the moment. And your answer to that is all that's irrelevant. History is irrelevant because they've said it's going to be fine. My question is, how do you evaluate a real risk in those rather stark circumstances? As a matter of law, perhaps?
Well, as a matter of law, you are entitled to accord respect, as the Divisional Court did, to the judgment that they will conform to and will comply with these arrangements, and that's detailed specific arrangements. And you are entitled to test, which is why I'm going through this exercise, particular aspects or examples of concern that have been raised to see if in the new world of the arrangements they continue to carry weight. That's why I went in some detail through the refoulement from the airport and contrasted it with the provisions that exist under the MOU requiring people to be cleared for the very purpose. That's why we've been considering financial and practical incentives. That's why in relation to legal assistance, I'm trying to address the question at a relatively high level, recognising that real risk is the test, for the purpose of seeing where we are. And the answer to that is we are in a place in which there is specific provision made in the MOU and in the NVs for the provision of legal assistance at each of the various stages. And whether that was so before or wasn't so before is neither here nor there. The fact of the matter is it exists. And the government of Rwanda are thinking about the criticisms that are made. So my submission in answer to my Lord is that you have to try and do the best you can, or the court has to try and do the best it can on the evidence. But the evidence does enable you, at least in part, to test the idea that, or the UNHCR thesis, now mounted with full vigour in this court as it was below, that says, well, you had a system which didn't work before and you just can't assume it's going to work now.
Presumably the correct legal basis, very basic stuff, is the burden must be on the claimants to show that there is a real risk, but that burden is mitigated by setting a low bar because it's only a real risk. I mean, it's very, very like the refugee test and also the test that the Israeli Supreme Court took.
Well, I'd agree with the first part of that, you won't be surprised to hear me say. But the second part one needs a little caution with. Of course, it's real risk. It isn't a finding. You don't need to make a finding on the balance probabilities or anything of that kind. It is a real risk that you have to confront. But it's a real risk, as I said when I was addressing the principles, which does have a strong element of prediction in it. And that prediction involves considering all sorts of things that bear on whether a foreign government that has given these arrangements will do the things that said.
I was just trying to identify the legal test.
Yeah.
Fairly trite, but I just want to make sure
the
same thing applied here as in other related contexts. Yeah.
Well, and it's the Strasbourg court is often keen to explain that substantial grounds for believing there is a real risk is a significant test.
Yes.
And one's always got to ask the question, the real risk of what? So, real risk of treatment contrary to Article 3, conceptually very straightforward. A real risk of refoulement in circumstances of the sort that we've been discussing, substantial grounds for believing. But my question really is there a danger in focusing too much on each little, I say little, they're very substantial and significant in themselves, but each part of the criticism, and asking oneself, is there a substantial ground, are there substantial grounds for believing there is a real risk, for example, that the the DGIE will have an inappropriate influence on the next stage up, without actually stepping back and asking the global question, which in the asylum context I think we'll come to in Ilias possibly, which is a bigger question about whether the system is going to essentially deliver wrong outcomes, isn't it?
Yes, my lord, I respectfully agree with that. In part, it's a kind of forensic product because one has to try and do the best one can to address the specific concerns that have been raised, hence the engagement with Rwanda, hence the way I'm trying to do these submissions to try and address them. But not merely do I entirely agree that it's very, very important to be able to stand back and view the wood, having tried to have a bit of a look at the trees. But there's also the broader point to be made, which is that ultimately this is an Article 3 challenge, and the Article 3 challenge effectively requires a system that, as it were, I'll put it this way, without delving into the legal test again, can't be trusted to deliver good outcomes, plus then removal to a actual refoulement to a place where they fear ill treatment.
Well, I was going to ask about that. It hasn't really been spelled out, but suppose there is a real risk that people who should be granted asylum status aren't. But suppose, and there is some suggestion of this in the evidence, it's a little bit difficult to bottom out, that they won't then be refooled, but will live an unsatisfactory life in limbo in Rwanda, where they won't have an official status. But there's a bit of evidence from the government of Rwanda saying nobody will be removed, and their position will in some way be regularised. And we haven't been much addressed on that.
No, or on the idea that they don't actually.
It follows on from my Lord's point, ultimately, and yours, we're talking about Article 3, which normally means refoulement. Now, it doesn't always, because MSS, the Article 3 risk there was partly refoulement and partly living in squalid conditions on the streets of Athens.
Yeah. And I think it is a broader perspective point rather than a freestanding argument. I mean, I can see an argument that says, or forcing the point that would say, you're entitled to have your refugee convention claim dealt with properly, come what may.
Well,
and the unsatisfactory treatment that might follow is a problem in itself. But at least one needs to bear in mind the sort of evidence that my Lord was drawing attention to. And I think it goes a little bit beyond what you were saying, which was that, and we slightly touched on it earlier, the idea that they don't actually have any returns arrangements. I think it from memory is the picture with the places where the ill treatment is feared. That, no doubt, in part explains why people will return to the place from which they bounced, as it were. But in this case, that would be the United Kingdom. So I would put that on the basis of agreeing with my Lord the Lord Chief on the procedural side, that you need to stand back and look at the thing as a whole, despite the forensic need to try and address the details to the extent we can do. Because otherwise I'll be accused by the Master of the Rolls of not confronting the real case that's being made against me, which is all about the practicality.
Who accused you of anything?
No. Lest the Master of the Rolls be tempted to accuse me of that.
Yeah, it might be tempted.
But stand back on the broader procedural picture, but also bear in mind that this is centrally an Article 3 case that says we're going to be removed, in which case you've got those two steps that have to go through.
yes, though, as you yourself fairly pointed out, I think I would have if you hadn't. If you're characterising Article 3 terms, the analysis I put you would seem to be the right one. But there may be a freestanding point that this deal is basically designed to
Deliver correct
outcomes as far as any system ever can. And if there's a real risk that won't happen, that's a sufficient ground of challenge in itself.
Yeah. But the point remains. The point remains, even if there is that alternative way of looking at the world, and I fully accept that that is a legitimate thing to do. But anyway, I was still on the UNHCR reasons for saying clean slate won't do, can't have regard to the arrangements, because it was, I'm not going to say busted again, but the system didn't work terribly well before and doesn't work terribly well now. It can't be expected to work terribly well now. And the next way in which it's, the next point on right to be heard in the UNHCR reference document appears to be there was no guaranteed hearing at the RSDC or the Menema stage, And what we say about that is there's nothing to stop the RSDC from having a hearing or from interviewing. It's up to them. It's not necessary for it to be guaranteed. They're obliged to deliver a fair and impartial process under the MVs, and that's what they'll need to do. And no doubt, if they should have had a hearing or they should have interviewed again, and that's a cause for concern, the lawyers can raise that in the appeal to the High Court if necessary. They would go first, of course, to the Manema appeal, where they will have an opportunity to make oral and written representations, and any legal representative will also have an opportunity to make submissions at that stage. C, and I took you to them, 5.1 to 5.5 of the asylum process intervenes. So again, nothing in the idea, there's no guaranteed for a hearing. High Court untested is the next point the UNHCR say. Well, our answer to that is we note they don't say independence, and I've made my submissions in relation to that. High Court is untested in this jurisdiction because no one's gone through the process yet, but I took you to the bit in the MOU that described the nature of the appeal to the High Court on fact and law. So even if there is...
Unfortunately, it said subject to the Rwandan rules, but we haven't got the Rwandan rules.
No, but my lord, it's fact and law, so anyway, I mean, there's nothing to indicate that they won't conduct a proper process. And indeed, even if it was a bit more like JR than a full-blown rehearing, or de novo hearing, if one gets to that level of sophistication, our submission would be the same. Which is
this may
still
be a mischievous question, but are there any Rwandan rules? It's easy to write down the name, but we have a 5,000-page book called the rules.
Well, I don't know. I'm afraid.
Hopefully more sensible than that.
Yeah, sorry, but I don't know the answer to that. As I say, the debate appeared to be about whether or not this was a full-blown de novo hearing or a JR type hearing. To which my answer would be, well, even if it's a JR type hearing, that's a jolly good protection.
But if there's never been one, how does anybody know?
On this jurisdiction? Well, the answer to that is it's provided for in the arrangements, and the jurisdiction will have to be set up. And the fact that it hasn't been operated yet is simply a function of the fact that no one's been able to be removed because you're considering the issue. No fresh claims was the final ground in relation to right to be heard or no right to be heard in the UNHCR thesis. And the assertion was made, I think in Mr. Botnick's second paragraph 87, aware of no mechanism.
Is that how he put it? Remind me, aware of no mechanism as opposed to there is no mechanism.
Aware of, UNHCR is also aware of no mechanism by which a person whose claim has been rejected under the RSD procedure can make a further asylum claim in Rwanda on the basis of fresh evidence or changed circumstances. To which the government of Rwanda responded, bundle 4, tab 67, page 1338, by reference to paragraph 87.
Which page? One.
Page 67.
Yeah.
Sorry, tab 67, page 1338.
Yeah. Thank you.
You see 87 just by the first hole punch.
Yeah.
It might be thought that's rather underpinned by the general commitment at 9.1.1 of the MOU about treating relocated individuals in accordance with the Refugee Convention and ensuring protection against refoulement. So if the position is that requires, which I'm sure it does, some provisions, subject no doubt to serious processes designed to, or rules designed to protect the integrity of the procedure, some provision for enabling new material to be considered, then that will no doubt need to be done. So the conclusion, just to draw those strands together, is that the core of this UNHCR theory that the arrangements will not rectify the faults that they'd identified or the concerns that they had about the old system, we respectfully submit it as a kind of easy a relatively easy allegation in general terms to make, but it does need to be viewed making judgments about the component parts upon which that is founded. And I've dealt with all the airport removals, gatekeeper and DGIE specifically, and we respectfully submit that when those component parts are actually looked at, there is plenty to suggest that there is no real risk. There's likely to be no real risk under the system as designed in the arrangements, and that the detail of those concerns when applied to the new arrangements simply does not stand up. I come back to the concern that the Divisional Court might not have done enough in relation to the UNHCR concerns as identified, the criticism that they took a couple of examples and then ignored the rest. Well, that is not a fair characterisation of what the Divisional Court did. They identified the nature of those concerns. We had masses of debate about this before, these ingredients, these elements, before the Divisional Court. They summarised those concerns in their judgment. But ultimately, their conclusion was that the arrangements were likely to deliver what they said they were going to do on the face, and that there was no real risk that they wouldn't do so. And for all of the reasons I've given, I respectfully submit that that was a proper conclusion on, and having considered the mass of evidence that was before the Divisional Court. Well, that is the first of the main areas. I was going to move to much shorter areas. I'll be delighted to hear something. They're going to get increasingly short, which is good news. The second general area was the general Article 3 risks in Rwanda and concerns about the substance of Rwandan law. And the short and overarching submission there is that judgment paragraph 73 to 77 contain no error. No error of principle and no error, not wrong on their analysis of the factual position. So far as dissent is concerned, and the worries about people expressing dissent in Rwanda, the Divisional Court specifically addressed that at paragraph 74. And we rely on that, providing a proper and clear answer to those concerns. There was a concern expressed about Article 15 of the Refugee Convention, and so far as that is concerned, again we respectfully submit that the position is that 9.1.1 of the MOU makes clear that Rwanda are going to ensure and will ensure that the asylum claims are processed in accordance with the Refugee Convention, Rwandan immigration laws and international Rwandan standards. And under the hierarchy of laws, under the Rwandan constitution, international instruments are placed above ordinary domestic laws. That's Article 95 of the Constitution, and if you want it, it's in the first supplementary authorities bundle number 25, tab 72, page 2319. The Divisional Court correctly concluded at paragraph 55 of the judgment that the UNHCR had themselves said that Rwanda's law relating to refugees was, quote, fully compliant with international standards. See the report at bundle 5, tab 95, page 1671. And the Divisional Court also rightly concluded, because there was a bit of a spat below about the state of Rwandan domestic law and all of that, that they concluded that they couldn't take the issues of Rwandan law forward in any meaningful way on the state of the evidence that they had before them. That's judgment paragraph 55. But the specific points that were then raised were then picked up and dealt with by the Divisional Court at paragraph 77. And we submit no error in relation to paragraph 77. That's all I wanted to say about that section of the Divisional Court's judgment. Effectively, we take our stand on the correctness of those paragraphs in a nutshell. So that's all I wanted to say about that. I was going to turn to Ilias and the procedural aspects next, which will only leave me with a short bit on Gillick. We note at the outset of this section of the submissions that this is where the Divisional Court started effectively, and I've done it the other way around for reasons I hope you'll understand. It may help, at least at this level, to see what the nature of the concerns are, to see what investigation might need to be done. But they started there, so this is dealt with in their judgment at paragraphs 46 to 61. And as you've already picked up and noted, this aspect, a bit like the substantive Article 3 issues, had a convention aspect, an Article 3 angle, an Ilias angle, and substantially the same points were then repeated under the guise of Temside rationality. Our overarching submissions here are that the Divisional Court applied the right approach to Article 3 and its case law, citing and correctly identifying the thorough examination test in Ilias. And they correctly identified and applied the correct public law principles, which are almost too well known to deserve mention on Temside, including ultimately that's a matter of rationality and rational judgment for the decision maker, see Cartoon and Balajigari, both very well known cases. I think only Cartoon is in the bundle, paragraph 35 of Justice Laws. If you want it, it's bundle 20, Core Authorities bundle, tab 28, page 390. So they applied the right approach in principle, is my submission. Secondly, they were not wrong in the conclusions they reached on the facts, that there had, in effect, to take the higher of the tests, been a thorough examination of safety and so on in Rwanda, and on any view, therefore, that reasonable and rational inquiries on the Temside had occurred. Indeed, it might be thought that the position in Rwanda has been the subject of not merely careful scrutiny, but the most careful scrutiny and consideration over a very considerable period of time by all concerned, both the Secretary of State and now the courts, and both aspects of that, as I'll come to in a moment, are relevant for Strasbourg practice at least. There is no question, to draw the contrast with the outcome and the reasoning of the court in Ilias, here, of anyone simply assuming, that was the problem in Ilias, that all was rosy in the garden of the receiving state in terms of its process. So to turn first to Article 3 and Ilias, this is ground 1 in the grounds of appeal in your enumerated grounds. We've dealt with it in our skeleton for this court at paragraphs 9 to 18. And just to amplify a little on the correct approach in principle, on Ilias I'm going to do correct approach in principle followed by not wrong on the facts. So correct approach in principle, a little bit of detail. You have Ilias, if you want it, in the raw at tab at bundle 21, Core Authorities, tab 69. I don't invite you to turn it up because you've got the relevant bits in the judgment. But if you want it in the raw, it's bundle 21, tab 69, 2813. And it's accurately dealt with, we submit, in the judgment at paragraphs 48 to 50. So 48 to 50, you'll see the relevant citations. And you'll see the reference in particular just emphasising that they applied the correct test, having quoted the right bits. Paragraph 50 of the Divisional Court's judgment, referring to they hadn't rested on the required thorough assessment. So they fully appreciate that that's what's needed to be done. We don't suggest, of course, that the sending state doesn't need to consider whether there's a real risk of Article 3 on treatment. It's got a form of view about that. And we don't suggest that it can simply presume that because they're signatories to a convention. You need, as the European Court decided, a thorough assessment. And that's what the Divisional Court held it. See both 49 and 50, the bits I've taken to you, and see the title above 46 in their judgment. And that express finding is flatly inconsistent with the idea that they didn't apply the thorough examination test laid down by that case law. There appeared to be some suggestion by Mr. Hussain that the use of the verb considered in some parts of the judgment undermined that. My submission on that is that it plainly doesn't. That's simply identifying various pieces in the thorough examination, looking at what was in fact considered by the decision maker. So it's a finding about compliance with the duty. It's not seeking there to unravel their earlier clear and express finding about what the nature of that duty was. We do put down a bit of a marker that says you need, however, to bear in mind, doesn't matter in this case perhaps because of the evident thoroughness with which it was done, but we do put down a marker that the nature and extent of what amounts to thorough examination for this purpose is something which is bound to be heavily fact dependent, and there is still some room within that concept we submit for the decision maker to make judgments about what areas to chase down, what bits need to be looked at further, and so on. So there's still some room for that, but we don't need to get sucked into that debate in this case. Here, contrary to the first and third criticisms that are made in the grounds of appeal against us, and those are dealt with in our skeleton in paragraphs 12 and 13 and 15, the Divisional Court plainly did undertake its own assessment of the evidence to see whether a thorough examination had in fact been conducted. See paragraphs 51 to 60 of their judgment. They on no view ignored or disregarded the views of the UNHCR. They were the subject of specific consideration, summary and evaluation in part by the Divisional Court. And so we respectfully submit that there is nothing to indicate that they went wrong in principle or misunderstood in some way the test clearly set out in the case law that they cited and the subject of an express finding or note by them that it was a required thorough examination. See whatever it was, paragraph 50. So that's the principal bit. The entitled to conclude that the duty was complied with, that's the Divisional Court entitled to conclude that the duty was complied with. We do again submit that all the points that they make in that section of the judgment which deals with this aspect were well and properly made. The key Ilias finding is perhaps at paragraph 59 of the judgment, and the key Temside finding is perhaps at paragraph 60 of the judgment. But they dealt throughout that section with what the Secretary of State knew, including when dealing with the adequacy of the Rwandan systems. There was no mere presumption that the thing would all be fine, of the kind that led to the finding of violation in Ilias. On the contrary, there was, on the facts, the most intensive consideration and investigation of the scheme imaginable. The headline summary of what actually was done to try and get to the bottom of all of this and to probe it is set out in Mr. Armstrong's statement at paragraph 17 and following, bundle 3, tab 26, page 1021 and following. This is not on any view, and was not on any view, some form of tick box exercise that Mr. Hussain sought to characterise it. The government collated relevant information, multiple departments involved, made a series of assessments about the Rwandan asylum system and immigration processes. It was based on a wide range of sources, as Mr. Armstrong's statement makes clear. including publicly available material, information gleaned on visits to Rwanda, meetings conducted with the Rwandan government, the Legal Aid Forum, the UNHCR. You remember the Annex 8 documents in the interview notes, and the 11-page summary of the discussions that occurred with them in March 2022. The true picture from the evidence, and again, my Lord, the Lord Chief's point about needing to stand back from this is well made in this context also, I respectfully submit. The true picture is that the level of inquiry that went into those decisions was incredibly intense, perhaps uniquely intense. And indeed, part of that process, as I keep emphasising, involved designing the negotiated arrangements, having undertaken the process of trying to understand what the nature of the concerns about the current system were. And we would add for good measure that it's a slightly different point, but we also respectfully submit that the Divisional Court was right in its approach to the date on which you view all of this. There was a section in paragraphs 41 to 42 of their judgment about whether you freeze it, as it were, at May, or whether you take into account all the information. And I respect the submission as they were right about that. And so we do submit that considerable efforts were made, considerable examination, and plenty enough to surmount the adjective thorough by the government in advance of deciding that people could safely be returned. So the Ilias duty plainly complied with by the government for all the reasons that I've given. I said that the UK courts have their own role to play in relation to this, at least when you get to Strasbourg, and they also have been involved, that's the UK courts will have been involved and have been involved in that examination of the risks. And the only reason I drag you into it, as it were, is because the Hungarian courts were dragged into it in Ilias, because the point was made in paragraph 158 of the European Court's judgment in Ilias that neither the authorities nor the Hungarian courts, I think it was, had conducted a thorough examination of all of that. I want to pick up one final point on Ilias, which is, I've dealt with UNHCR sufficiently, but which is the reference to the Independent Advisory Group on Country Information. There was a report by that, the beginnings of a report by that government body, and there was some reliance on that by Mr. Hussain, I think. That report, if you want it, is at bundle 4, tab 80, page 1441. I don't invite you to turn it up now. It dealt with in the judgment of the Divisional Court, paragraph 59. And the position, as there pointed out by the Divisional Court, we respectfully submit correctly, is that they've got a statutory role under the Borders Act 2007 to consider and make recommendations about various bits and pieces to do with countries outside the UK, which are connected with asylum. And the short point is that that process is ongoing. It was ongoing at the date of the Divisional Court judgment. So I think we reached a stage where the Home Office was about to put in effect a government response of the kind that you do to Divisional Courts of that kind. So nothing of substance in there to suggest that it wasn't thorough. That's just one aspect of the process. There's an independent set of eyes on it. So that's Ilias. Temside, we've dealt with in the criticisms there of the Divisional Court. We've dealt with in our skeleton for this court at paragraphs 19 to 23. This is ground 2. My first submission is that it's a pretty unpromising ground if you failed on the thorough examination aspect of Ilias. The Temside. Well,
I think Mr. Hussain in the end suggested that it was really the timing point.
Yes.
That kept the Temside argument alive.
Yes, my lord, but I respectfully submit that the judgment at paragraphs 41 and 42 are correct in relation to that. That's probably all I need to say about that. If you're considering under Temside, if you're looking at the, as it were, the temporal window under Temside. It seems a little illogical not to take it right up to the date on which the decision was made, but judgment paragraph 41 and 42 is probably sufficient for my purpose. That leaves Gillick. I'll have to say if I've understood the Gillick argument correctly, but that leaves Gillick. Gillick is dealt with in paragraph 72. Dealt with in judgment paragraph 72, and no error there, I respectfully submit. They now, as we point out in our skeleton to this court, seek to rely upon a kind of new point based on Munjaz, which doesn't appear even to have been cited below, and there are questions about whether that's a right approach. But in any event, the Divisional Court's analysis applies the right test based on A, my Lord Warner may remind me of that, the point that says, well, does the policy itself encourage or permit or condone unlawfulness, and relies on the right factors for concluding that the inadmissibility guidance is lawful. And I also submit, before coming to Ms. Naik's primary and alternative cases, that it is not merely perfectly acceptable in public law terms, but also evidently good administrative sense to have generic guidance about the positioning on safety in a country like Rwanda in a context such as the present, because although, of course, final decisions have got to recognise and take account of the personal circumstances of any which might trigger risks, it obviously makes good sense that individuals are not seeking, nor will they be able to reinvent a wheel as large as that. So the primary case that was advanced orally, if I've understood it, is that the policy creates a risk of a breach of Article 3 because the direction to the caseworkers is said to presume that Rwanda is safe, but then make the claimant do something they practically can't do, which is to show why not. That appeared to be the description of the way in which the primary case is put. And in answer to that, it's clear, I respectfully submit, that that policy or that guidance does not itself give rise to harm. It doesn't authorise or approve or require removal in the face of a real risk. On the contrary, it indicates that the caseworker should consider the generic guidance. That's entirely appropriate for all the reasons I've given, but also that they need to consider all representations made about safety, both generally and in relation to the personal circumstances of the individual. And the judgment at paragraph 72 rightly, we respectfully submit, quoted the words from paragraph 345B of the immigration rules. And if the claim is based here that they can't make effective representations, that rather collapses into the broader fairness points which are going to be dealt with by my learned friend Lord Panic. So we submit that the primary case doesn't apply. The alternative case appeared to be that even if there's no real risk, the policy is unlawful, or the guidance is unlawful, because, and I call it D2, you'll know what I mean, 345D2, because D2 and potentially criteria or factors that might be covered by D2 are not covered in the body of the guidance. And I give these answers to that case, just in case you want it. The inadmissibility guidance is at volume 3, tab 21, and it starts at page 964. The answers we give to that case, if I've understood it correctly, are first of all that there is no, we submit, no legal requirement in public law for policies covering an area to be exhaustive in the sense of providing guidance about everything to do with that subject matter. The immigration rules exist, and there is no reason to suppose that the process they envisage will not be followed, including the consideration of exceptions. If the point is that there is a real risk, the allegation is there's a real risk of effectively of D2 slipping through the decision-making cracks.
Sorry, I'm being incredibly stupid, but I didn't understand the D2 expression.
I'm so sorry, my lord. Will you go to page 991?
I thought it would become clear.
It's just that it's the rule we're talking
Yeah,
about,
yeah.
isn't
Will
it?
you go to
It's
line-
rule-
D2, the rule.
It's a rule.
Three,
Every
four,
345 D2.
Thank you.
I'm so sorry.
Sorry, I
No,
just was bemused. I thought you were talking about a person.
no, I'm not talking about a decision. No, I'm not talking about a person or a decision.
R2.
I'm talking about a rule, and the rule is at page 991 if you want it.
It's all right. I know where D2 is now.
It's been a long day.
Not over yet. It's a joke.
So I'm addressing the question: is there a real risk of D2 falling between the cracks? And the answer I give to that is no.
You can now see why I
Yes, I can.
became more and more lost.
Yes, the answer to that is no. Nigel.
Yeah.
On the same page at least. Firstly, because the guidance on page 969 at the bottom specifically requires that this set of guidance be read alongside related lead instructions of the kind that are dotted at the bottom of 969 and 970. And that's of interest because if you go back to the rules that are quoted at 990 and 991, you see 345A, 345B, all very familiar, 345C and then D. And you'll see the basic structure and what D is about. D starts from the premise, at least on its face, that the application has been declared inadmissible, and then it's setting out reasons for, as it were, retreating from that position in Roman 2 upon consideration of the claimant's particular circumstances. So even though the country is safe, you might want to retreat, is the point. And that, therefore, is going to be referring to and covering territory, which is to do with things like you've got a terminal illness or there's a particular family reason for not wanting to go, whatever it may be, but there are circumstances that don't necessarily bear on safety. So just to finish this point, the related instructions and their topics and subject matters, as you will see, will in a very considerable number of cases at least, cover precisely that category or type of information, because those related instructions, they're not in the bundle because no one thought that they were going to be relevant, we're going to end up in this place, but you'll see just from the titles, you've got medical claims under Articles 3 and 8, family members Appendix FM, special leave outside the rules and all of that, discretionary leave at the top of page 970. So at least one aspect to bear in mind is that this guidance requires those things to be thought about alongside this guidance. The second point to bear in mind is that the relevant immigration rules, because the concern here is that they're not going to, because it isn't referred to specifically in the body of the document, they're not going to bother with it, or it's not going to be thought about properly. But you will have noted, the reason I've conveniently quoted at page 990 and 991, but the feature on which I place reliance for this purpose is that that document is part of this guidance, and it shows you the sequence of the rules, and it tells you that it's got 345D2 in it as well. So you've got.
If I were a caseworker, even with some training, using this guidance, I think I would expect to find in it some help about what 345D, what considerations are relevant to 345D, and a reminder at any rate I've got to look at it.
There are two different things. I'm not entirely sure what help my lord would expect if you were a caseworker looking at D2, which simply refers to particular circumstances about it being inappropriate despite the thing being safe. I mean, that's going to cover personal circumstances.
Yeah,
I'm not sure
all right, then, but simply a reminder when all this is done and when you've decided on inadmissibility, or at any rate on say third country, there is a further step to be done. Maybe look at anything that's been put in front of you, or that is obvious from the papers, that might make it inappropriate to return or to send the applicant to, in this case, Rwanda.
Well, it might not necessarily even be, I don't want to give a glib answer to a serious question, but it might not even be when all this is done. Of course, that's the structure of the rules,
Yes,
the logical structure of the rules which are quoted, and they aren't that complicated in terms of the structure. But it may well be, and this is perhaps the bull point on real risk, it may well be that these sort of features are produced at any stage of the process.
Yes.
And the reality is
there may be some overlap.
There may be some considerable overlap in time. And
medical cases in particular.
Yes, and the bull point that you would is that you would really expect not merely legal representatives to understand how all of this works, and that was a relevant thing to say, but almost inconceivable that something which might be appropriate circumstances for the purpose of D2, they would not be raised by a claimant who was not even legally represented, because they're going to have to be of sufficient seriousness to cause the non-removal to a country which by definition is safe.
If there were any unlawfulness here, it would be very easily solved by a paragraph saying, don't forget 345D2.
Well, that also is true, but I'm seeking to persuade you of the prior point, as you'll understand. And the
see where this point goes.
Yes, but the prior point goes to the practicalities, because this is about real risk, if it's anything, even assuming you're in that territory. This is about real risk of an immigration caseworker not considering D2 in circumstances where those sorts of personal circumstances would be produced, and in which all of the sorts of things, sorts of areas where they might be produced are the subject of related instructions which must be read alongside this one. So
well, that has to be looked at in the context of A in the Supreme Court, and the case decided, well, heard at a different time, but I think judgment given at the same time in BF.
Yes.
Which from memory did deal in passing with the question of something further might have been said.
Yes,
but
well,
maybe
I
we
mean,
can check that overnight.
Yes, I'm reminded it's paragraph 47 of there.
Thank you.
Yeah, thank you. But my point is the intensely practical one, which is it doesn't matter at what stage of the process this happens. Lots of the sort of subject matter that you'd expect someone to raise if they were going to raise appropriateness under D2 is going to have to be raised under the thing anyway. It can be raised at any stage, and so you're really left with the idea that there's a real risk, even if that's the test and that's the way it works. You're left with the idea of a real risk that someone is going to not raise these points, because if they do raise it, throughout this document, caseworkers are being told react to the representations that are made to you, including about personal circumstances. And indeed, as you've seen from the earlier parts of the immigration rules and the guidance, issues of safety and all the rest of it have to take account not merely of the general, the generic analysis of Rwanda as a safe country, or not in general terms, but the particular circumstances of the individual. So for all of those reasons, we submit that there is really nothing in the attempt to drag Munjaz in at this late stage. I've left Lord Panic with a deathly 10 minutes. I could probably filibuster for 10 if you'd like me to, or the court may think you've had enough time already.
I think Lord Panic will be able to deal with the next 7 minutes very well.
That's me done, unless you have further questions.
Thank you very much, my lords. As the night watchman, can I identify, first of all, the issues I'm going to address? And there are 4 of them. The first of them is whether removal to Rwanda breaches the Refugee Convention, even if, based on my friend Sir James's submissions, it is a safe third country. Secondly, whether removal to Rwanda is unlawful because of EU law. Third, whether the Secretary of State has acted unlawfully by using the powers in Part 5 of Schedule 3 to the 2004 Act. And fourthly, the complaints about unfair procedure. Mr. Hopkins, for the Secretary of State, is then going to address data protection to the extent that your lordships require assistance on that matter. In relation to the Refugee Convention, is it breached even if, as Sir James has submitted, Rwanda is a safe third country? There are two distinct but overlapping submissions that your lordships have heard from my friends. The first of them is Mr. Hussein's submission. He says removal to Rwanda breaches Article 31 of the Refugee Convention because it is a penalty. And secondly, Mr. Drabble, for his part, says removal to Rwanda is a breach of the Refugee Convention because the Secretary of State has declined to consider the merits of the asylum applications without any reasonable basis to do so, particularly because the individuals have no prior link to Rwanda. My submission on behalf of the Home Secretary is that it is not a penalty or otherwise a breach of the Convention to remove a person to a safe third country consistent with Article 33, and it makes no difference if such removal is to what is said to be a less attractive asylum system, so long as it complies with Article 33, and it's irrelevant whether there is any prior link with Rwanda. And I so submit for a number of reasons. The starting point is what the appellate committee said in Bugdakai in 1987 appeal cases. It's core authorities. If your lordships could please go to core authorities 19, it's tab 20 and it's page 528. Judgment February 1987, Lord Bridge speaking for the appellate committee at page 532 of the judgment and 546 of the electronic bundle. 532 of the judgment, just under letter A, a celebrated, well-known passage. My lords, I can well see.
So sorry. Which page?
Page 532 of the report. 546 of the electronic bundle.
Sorry. Yep, got it.
New paragraph just under A. My lords, I can well see if a person arrives in the UK from country A, claiming to be a refugee from country B, where country A is itself a party to the convention, there can, in the ordinary case, be no obligation on the immigration authorities here to investigate the matter. If the person is...
It must be the time of the afternoon. I still haven't found the passage. What? Give me one more time. Give me the number in the printed report.
532.
In the judgment of Lord Justice Hobhouse.
No.
I'm
sorry.
not in the right
It's
case.
tab 20, Lord. Tab 20.
Tab 20. I'm so sorry. I've turned over two cases.
Tab
Confusingly,
20.
the page references are very similar. Right.
Page 532 of tab 20.
I have it at last.
I'm grateful. Just above B, my lords, I can well see if a person arriving in the UK from country A, claiming to be a refugee from country A, where country A is itself a party to the convention, there can, in the ordinary case, be no obligation on the immigration authorities here to investigate the matter. If the person is refused leave to enter, he will be returned to country A, whose responsibility it will be to investigate his claim to refugee status, and if it's established, to respect it. This is the international practice. The practice must rest upon the assumption that all countries which adhere to the convention may be trusted to respect their obligations under it. It's an obviously sensible practice. Nothing I say is intended to question it, but it's not difficult to imagine a case where reliance on the international practice would produce the very consequence which the Convention is designed to avoid, and that's indirect refoulement, and Lord Bridge deals with that. So removal, without considering the merits of an asylum claim, is long established, and it's consistent with the Travo to the Refugee Convention, which the court will find in the same bundle, I'm sorry, not in the same bundle, in bundle 25, Supplementary Authorities, bundle 25, at tab number 71, at page 2225. And this is the work of Dr. Paul Weiss, who analysed the Travo, and the court will see from page 2225 who Dr. Weiss was. He was the head of the legal division of the office of the UNHCR. Tab 71, my lord, page 2225.
Yes, I was
and your
catching
lordship
up,
see in the middle of page 225 Dr. Weiss's expertise. He was, in fact, heavily involved in the preparatory work for the Geneva Convention. And your lordships will see on page 2227, in the penultimate paragraph under the heading Commentary, Dr. Weiss tells us Article 31 refers to penalties. It is clear from the Travo that this refers to administrative or judicial convictions on account of illegal entry or presence, not to expulsion. And if your lordships turn over the page, in the middle paragraph, your lordships see at 2228 in the middle paragraph, paragraph 1, that's Article 31.1, does not impose an obligation to regularise the situation of the refugee, nor does it prevent the contracting states from imposing an expulsion order on him. However, a refugee may not be expelled if no other country is willing to admit him. It's very clear. That is what the Travo states. There's no obligation on the state, whether under Article 31 or otherwise, to consider an asylum claim. It's not a penalty to remove the individual concerned to another state. And that has been recognised by commentators.
Well, I wonder, Lord Panic, whether we may move to the other commentators tomorrow morning, and no doubt to the Canadian case as well.
10:15 tomorrow morning?
Yes, 10:15 tomorrow morning. Now, can I just make one observation at this stage? The appellants, as it were, and I include UNHCR obviously within that, and all those who were making submissions before Sir James got to his feet, in the timetable which was agreed, had said 2.5 hours for reply. Now that's been truncated by 15 minutes for the reasons we know about yesterday. It means you've lost some minutes, but I would invite all of those who are expecting to reply to have agreed the order and division of the 2.25 hours available before we start tomorrow morning.
I think to be accurate, my lord.
Have I got my times wrong again?
Well, can I suggest, my lord, they took in fact 40 minutes longer than was allocated.
Yes.
Because my friend Mr. Gill started at 10:15 this morning and finished at 5 to 11.
All right.
And Sir James should have started this morning.
Yes. Well, can I leave everybody to discuss this sensibly once we've risen, and can I assure you that we do not expect to be receiving submissions in the morning about who should have 5 minutes here or there. I'm sure you get the point collectively.
Thank you very much.
Bye.